I just started to do some research, and quite frankly, I've only candidly found a case. It's in the 4th DCA, but it concerns a civil matter. And it speaks of the need for discovery cutoff to avoid the very term I used, ambush and surprise. And that when a party conducts itself in a way as to ambush, they're not to get the benefit of that. These trials, we understand, life goes on beyond trials. So the evidence that can be introduced into a trial should have some finite and determinable parameters. The notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signing, co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about it, we're going to go do it and introduce it while the proceedings ensue, is not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, or any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence and there are no lines and no parameters of propriety. The state is making a representation by bringing this indictment that they are ready and they have proof beyond a reasonable doubt. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward.
God, he's good.
And so, as the Fourth Circuit said, that is ambush. And the purpose of, the Fourth DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit of it.
Thank you.
Thank you.
Hold on.
Just briefly, I would mention that defense hasn't yet to provide any reciprocal discovery, but alluded to some yesterday that they were looking at Instagram posts and everything that happened as recently as this week. But yet
Because they're still
provided
looking at it. You have this. You had this and you
if there's
didn't give
any
it to them.
deadline,
That's
then it's
different.
what needs to be imposed on both parties.
No.
Thank you. Oh, Counsel, my understanding is that's the way it works, is that it's not emergency violations apply to both sides, doesn't apply to just one side. It's deadlines apply to both sides. That's not what it's all about.
I do apologize, the printers decided to not working. Let's work on it. I'm sorry.
I apologize. What I'm saying is that the whatever obligations that are imposed would be applicable to both sides when there's discovery cutoff or not. My thought is that the discovery cutoff, you can keep investigating the case, however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as in evidence. This thing with Mr. Moretti, where when I'm out of town on vacation, you're asking the detective what he's offering. I'm not really sure how it happened, to continue and run this through another process. And the defense doesn't know about it. The defense cross-examines Mr. Zellner, or Officer Zellner, and is not aware that he's asking questions about other programs, because his understanding is there isn't any other program. But you know there's another program, they have access to it, and they've done it. You just don't have the results. That seems to me to be what the council's talking about. And that seems to me to be a Richardson violation. You've discovered it's ongoing, you know about it, and you're not telling them about it until we're here in court. So as far as already is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I think the only way it can be cured is he's not going to testify about this second procedure that happened.
Wow.
It's not coming in. Same thing. If you want
There you go.
to
The
investigate
judge
case,
dropping the hammer on the
you do
prosecution
it.
again. Discovery violation. They do not get to talk about anything
Change your
new.
mind as to how you proceed with the case. And
Regarding
I don't have
the
a
second
problem. You can investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think a cutoff needs to be happened, because this is what's going on. We're going to have this. If you find something new, there's a whole, as counsel describes it, that and you. try
They've
to
had
find evidence
4.5 years to
to plug up the
investigate
hole.
this.
That's new discovery. The defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So,
So it's clear, this was not a new item. This was just this, all of the information was supposed to be identical.
you found it, you had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right, got a meeting with him in May after we picked a jury, and when we're ready to, or we're in the middle of jury selection, you picked it, you did it, and you said, well, he tells you, or you ask him, do you have more programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore, you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple of weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it. All right. And, but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him. And then you say, when it comes up at trial, say, what was it? I don't have the report yet. That's why I didn't turn it over to him. It didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation.
Yep.
Okay.
This judge is based.
As far as the detective already.
That's it. If you find any information that's disclosable to the opponent,
that's not coming.
you must tell them
Right, that's the
immediately,
sanction.
not wait weeks and then spring it on them
If you
suddenly.
have other information.
You have a duty to disclose it, the discovery immediately.
Right now, if you don't have
Exactly.
it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic.
Understood, Your Honor. And so everything has been turned over. That was the only item of which there was additional investigation done on to see if there was any other.
The judge
information.
ruled, let it go.